At 12:01 in the morning on July 24th, one American global tariff expired. At that exact same minute, another one took its place. There was no empty space, no tariff-free morning, no gap for importers to use. 60 trading partners were immediately placed under new duties of 10% or 12.5%. Together, those economies accounted for 99.4% of everything the United States imported. The European Union was included. China was included. Japan, India, Mexico, Canada, Australia, Brazil, and the United Kingdom were included. 4 months earlier, the Supreme Court had ruled that President Donald Trump could not use a national emergency law to impose his sweeping global tariffs. Many people assumed the tariff wall had been broken. They were wrong. Trump did not abandon the wall. He changed its foundation. The new tariffs were built under Section 301 of the Trade Act of 1974, a slower and more procedural law that had already survived major court challenges in the past. The headline was about forced labor. The deeper story was about rebuilding an entire global trade regime in a form designed to be much harder to destroy. If you want to understand where money moves after the political headline disappears, subscribe to the Mercer Ledger now, because this story is not simply about another tariff announcement. It is about what happens when a president loses one of the most powerful economic tools in court and immediately begins assembling the same power from different pieces of law. To understand what changed on July 24th, go back to the beginning of Trump's second term. In 2025, the administration declared national emergencies involving trade imbalances and drug trafficking. It then used the International Emergency Economic Powers Act, better known as IEPA, to impose tariffs across much of the world. The rates were aggressive. Some so-called reciprocal tariffs reached as high as 50%. China faced additional duties. Canada and Mexico were targeted through emergency declarations. Almost every major trading relationship was suddenly exposed to decisions made directly from the White House. IEPA offered something Trump valued enormously: speed. The law allowed the president to act during a declared emergency without completing the longer investigation, consultation, and public comment procedures required under traditional trade statutes. Declare the emergency, announce the tariff, set the date, begin collecting money. For an administration that viewed tariffs as economic leverage, industrial policy, government revenue, and negotiating pressure all at once, that speed was extremely useful. But there was one problem. IEPA never explicitly said the president could impose tariffs. It gave the executive branch broad authority to regulate international economic transactions during an emergency. The administration argued that regulating imports included the power to tax them at the border. Businesses and states challenging the tariffs disagreed. Their argument was simple but constitutionally important. Tariffs are taxes. The power to impose taxes belongs to Congress. If Congress wants to delegate part of that power to the president, the statute must actually provide that authority. On February 20th, 2026, the Supreme Court ruled that IEPA did not authorize the president to impose tariffs. The decision struck down the legal basis beneath Trump's most sweeping worldwide duties. It also exposed the government to refund claims involving tariffs already collected. This was a major defeat, but it was not a decision declaring tariffs themselves unconstitutional. The court did not say a president could never impose import duties. It said the president could not use that particular emergency law to do it. Other statutes remained available. That distinction became the entire strategy. The administration's response came almost immediately. Washington turned to Section 122 of the Trade Act of 1974. That provision allows a temporary across-the-board tariff to address balance of payments problems. The White House imposed a 10% global duty, but Section 122 came with a clock attached. The tariff could last no more than 150 days. That made it a bridge, not a permanent foundation. The administration now had 150 days to replace a fast emergency tariff with something more durable. The clock would run out on July 24th. While importers were paying the temporary 10% levy, the Office of the United States Trade Representative began building the next legal structure. On March 12th, USTR opened 60 separate investigations under Section 301 of the Trade Act. Section 301 is one of the most powerful traditional trade enforcement tools available to an American president. It allows the United States to respond when a foreign government's acts, policies, or practices are found to be unjustifiable, unreasonable, or discriminatory, and to burden or restrict American commerce. Trump had used Section 301 during his first term to impose major tariffs on China. Those tariffs survived legal challenges. That history mattered. Unlike the emergency law, Section 301 contained a process specifically built for trade action. There had to be an investigation. There had to be findings. Foreign governments had to be consulted. Businesses and other interested parties had opportunities to submit comments and testify. The procedure was slower, but every completed step added another layer to the legal defense. The 60 investigations focused on one common allegation. The administration argued that America's trading partners had failed to prohibit or failed to enforce prohibitions against imports produced with forced labor. Forced labor is a genuine global problem. The International Labour Organization estimated that 27.6 million people were living under forced labor conditions on any given day in 2021. The United States has prohibited imports made with forced labor for nearly a century. Customs officers can detain shipments when evidence suggests that forced labor was involved in producing them. The Trump administration argued that other countries were not doing enough. That failure, Washington said, allowed goods connected to abusive labor practices to enter foreign markets, move through global supply chains, and distort competition faced by American businesses. The moral argument and the trade argument were fused together. If another country did not police forced labor imports effectively, the United States would impose a cost on that country's goods. But the extraordinary part was the scale. This was not one investigation into one product from one country. It was 60 investigations moving in parallel. USTR consulted with more than 45 of the governments involved. 2 rounds of hearings were held. More than 2,100 public comments were submitted across the investigation and action phases. More than 100 witnesses testified during July hearings. On June 2nd, USTR determined that the practices of all 60 economies were actionable under Section 301. The administration had less than 8 weeks remaining before the temporary global tariff expired. The replacement was now moving into position. On July 23rd, the final action was announced. At 12:01 the next morning, it became effective. The timing was surgical. Section 122 expired. Section 301 arrived. The tariff floor remained. The new system divided trading partners into several groups. 17 economies received a 10% Section 301 rate. They included countries that already had some form of forced labor import restriction, had promised to adopt one through a trade agreement, or had created a partial system addressing certain goods. That group included Canada, Mexico, India, the United Kingdom, Argentina, Bangladesh, Cambodia, Indonesia, Malaysia, and Pakistan, among others. Most of the remaining investigated economies received a 12.5% rate. China and Australia were placed in that category. The European Union, Taiwan, Japan, South Korea, and Switzerland received a slightly different calculation. For specified goods, the new Section 301 duty was adjusted against the existing most favored nation tariff, so that the combined rate reached either 10% or 12.5%. That detail prevented the new action from automatically pushing some existing trade agreements beyond previously negotiated tariff ceilings. This was not simply a flat tax pasted onto every shipment. It was a legal and customs architecture. Country of origin mattered. Product classification mattered. The existing tariff rate mattered. Trade agreement eligibility mattered. The exemption list mattered, and that list was substantial. Oil and gas were exempted. Certain fertilizers and food products were exempted. Aircraft and aircraft parts were exempted. Critical minerals were exempted. Products already facing national security tariffs under Section 232, including many automobiles, steel, aluminum, and copper goods, were generally outside the new action. Goods receiving favorable treatment under the North American Trade Agreement also received protection. Officials added approximately 471 products to the exclusion list before the action became final. The reasoning behind those exemptions revealed where America remained vulnerable. The government spared raw materials that could become unavailable inside the United States. It spared products capable of causing economy-wide disruption. It spared goods America could not produce in sufficient quantities or obtain easily from another source. And it spared some products when an exemption could encourage a trading partner to strengthen its forced labor rules. This is how modern tariff policy actually works. The public sees one number. Customs brokers see thousands of classifications, exclusions, origin rules, and overlapping legal authorities. Two products arriving on the same ship from the same country can face completely different treatment. One may pay the new Section 301 duty. Another may be exempt because it is an energy product. A third may already be subject to Section 232. A fourth may receive special treatment under a trade agreement. The headline says 12.5%. The invoice depends on the code. This complexity helps explain why the market reaction was initially limited. The new duties replaced a temporary 10% tariff that had already been in place. For many products, the effective change on July 24th was relatively small. An importer paying 10% under Section 122 might now pay 10% under Section 301. The number on the invoice barely changed. The legal durability did. That is, the part investors could easily miss. The administration was no longer depending on a 150-day bridge. It had moved on to a statute with a longer history of surviving trade litigation. The immediate economic shock was modest compared with a brand new tariff appearing from zero. The long-term policy signal was much larger. The tariff wall was becoming permanent infrastructure. That does not mean the new action is immune from challenge. A lawsuit was filed almost immediately in the specialized trade court. Critics argued that the forced labor rationale was being used to recreate worldwide tariffs the Supreme Court had already rejected under a different name. Trading partners also challenged the logic. Australia called the tariffs unjustified. Brazil objected. Norway said there was no basis for the action. European officials pointed to their labor protections and questioned the accusation that they were failing to confront forced labor. Critics in Washington asked why countries with very different labor laws and enforcement records could face similar tariff rates. China and Australia, for example, both received 12.5% under the new structure, despite enormous differences in their economies, institutions, and relationships with the United States. The administration's answer was that the tariff categories were based on forced labor import prohibitions and their enforcement, not on a general ranking of domestic labor conditions. That distinction will be tested politically and legally, but Section 301 gives the government something IEPA did not: a trade-specific record. Investigations were opened. Foreign practices were identified. Consultations were conducted. Comments were received. Hearings were held. Findings were issued. Exemptions were adjusted in response to economic concerns. Every one of those steps can be used to argue that the tariffs were not an unlimited emergency tax invented overnight. They were the outcome of a statutory trade enforcement process. Whether that process is enough will ultimately be decided in court, but it is already a stronger defense than the argument that a general emergency law silently included the power to tax almost every import on Earth. For businesses, the legal difference creates a practical problem. Tariffs change behavior long before a judge rules. Retailers had already rushed shipments into American ports before the July deadline. Import volume at major container ports was expected to reach a record as companies tried to stock warehouses before another policy change. This front-loading can make the economy look stronger temporarily. Ports become busier. Inventories rise. Imports surge. Transportation demand increases. Then the deadline passes. Orders slow. Warehouses begin selling what they accumulated. The apparent boom becomes a hole in future demand. Tariffs also move through prices unevenly. The American importer pays the duty first. The importer can absorb some of the cost through a lower profit margin. It can demand a discount from the foreign supplier. It can redesign the product or change the source, or it can raise the price charged to American customers. Most companies use some combination of all four. Footwear offers a clear example. Industry representatives said manufacturers had already been increasing prices to retailers in anticipation of the new duties. By June, overall shoe prices were up 4.1% from 1 year earlier. Children's shoe prices were up 4.7%. Tariffs were not the only cause. Energy and transportation costs also mattered, but the direction was clear. Businesses were still passing costs through the supply chain. This is why the legal durability of a tariff can matter more than a one-day change in the rate. A temporary duty may be absorbed while a company waits for it to disappear. A tariff expected to remain for years changes investment. Factories reconsider where components are sourced. Retailers redesign private label products. Foreign suppliers move final assembly. Customs departments hire more specialists. Companies spend money proving origin instead of expanding production. The tariff becomes part of the business model, and the new Section 301 action may only be the beginning. The administration was already pursuing another investigation involving excess manufacturing capacity. That process targeted 16 trading partners, including the European Union, China, India, Japan, South Korea, and Switzerland. Additional sector-specific tariffs remained available under Section 232. Other country investigations could use Section 301. Trade agreements could set ceilings for some partners while leaving others exposed. The future tariff system would no longer be one giant executive order. It would be a network. Section 232 for national security industries. Section 301 for foreign trade practices. Section 122 for a temporary bridge. Section 338 for claims of discrimination against American commerce. Different laws. Different procedures. Different product lists. Different legal risks. That fragmentation may make the system harder to understand. It may also make it harder to destroy with a single court decision. If one authority falls, the others can remain standing. This is the real lesson of what happened after February. The Supreme Court removed the fastest and broadest legal tool from Trump's tariff strategy. The administration responded by trading speed for durability. Under IEEPA, the White House could move almost instantly, but could not persuade the court that the law authorized tariffs. Under Section 301, the government had to investigate for months, consult other countries, receive testimony, and construct a detailed record. The process was slower. The finished product was stronger. There is still an economic contradiction at the center of the policy. The administration says tariffs protect American workers, punish unfair practices, and strengthen domestic production. Importers and retailers say the same tariffs raise their costs and eventually increase prices for American families. Both effects can occur. A protected steel mill can benefit while a manufacturer buying steel pays more. A domestic producer can gain market share while a retailer loses margin. A tariff can encourage investment in America while making every imported component more expensive during the years required to build that new capacity. The final result depends on time, and time is exactly what the new legal foundation is designed to create. The administration wants businesses to believe the tariffs will remain long enough to force permanent changes. Trading partners want companies to believe negotiations will produce exemptions before supply chains move. Consumers are caught between those two expectations. The 50-state American economy is now surrounded by a tariff wall made from multiple statutes, not one emergency declaration. That wall has doors. Oil passes through. Certain fertilizers pass through. Aircraft parts, critical minerals, and selected food products pass through. Trade deals open other doors. Product exclusions open hundreds more. But for much of global commerce, a 10% or 12.5% floor now remains. 60 economies. 99.4% of American imports. One tariff expired at 12:01. Its replacement arrived at the same minute. The Supreme Court won the legal argument over IEEPA. Trump kept the tariff wall. And the next battle will not decide whether tariffs exist. It will decide how many different laws Washington can use to keep rebuilding them. If this video helped you see the legal structure behind the economic headline, subscribe to the Mercer Ledger and turn on notifications. Then tell us in the comments, is the new tariff wall a legitimate defense against forced labor or a legal workaround that American consumers will ultimately pay for?